Some of the basics that underlie Miranda, both at the federal level and New Jersey interpretations of those. So let's start with the beginning, and we've talked a little bit about the Fifth Amendment, and just so you know what it says, in case you haven't pulled out your copy of the Constitution recently and read it, the Fifth Amendment says no person shall be compelled in any criminal case to be a witness against himself. And that's what all of this is about. In 1964, which may seem ancient to many of you, but is actually quite recent in terms of United States constitutional history, it was not until 1964 that the Supreme Court of the United States decided to apply the Fifth Amendment to the states by determining that the privilege against self-incrimination is a fundamental guarantee of the Constitution and therefore should be applicable to the states through the Due Process Clause of the 14th Amendment. Up until that time, that is up until 1964, the Fifth Amendment to the Constitution only applied to the federal government. As applied to New Jersey, New Jersey does not have a constitutional provision which matches up with the Fifth Amendment. That does not mean, however, that our state doesn't follow Fifth Amendment law. Rather, what it means is that New Jersey has had a common law basis for utilizing the Fifth Amendment. From the very time that New Jersey became a state, it followed what became in the federal government Fifth Amendment law. So New Jersey does not have a Fifth Amendment, does not have any constitutional provision that is equivalent to the Fifth Amendment, but this privilege against self-incrimination applies in New Jersey just as well as it does in the federal government, not just because the Supreme Court said it does through Malloy versus Hogan, but because New Jersey in its common law has applied that privilege way back to when New Jersey became a state. That common law privilege has been codified both in statutes and in our rules of evidence. If you look at your lesson plan, you'll see NJSA 2A84A-19, which says every natural person has a right to refuse to disclose in an action or to a police officer or other official any matter that will incriminate him or expose him to a penalty or to a forfeiture of his estate. Now, those of you who are familiar with our statutory scheme will recognize that 2A, Title 2A, is not all that old in our New Jersey history. And you may say, well, how come you're talking about common law going back to the time New Jersey was formed as a state when you're talking about a statute that was not adopted until some relatively recent time? And the answer is that 84A there, the statute that's listed up there, is only the most recent adoption of the statute. It's not the first time that the statute existed. In fact, the statute was adopted in its first form in 1855. Secondly, if you look at the language of the statute, the first part of the statute seems clear enough. Every natural person, which means a human being, not a corporation or an unincorporated association like a labor union, has a right to refuse to disclose in an action or to a police officer or other official any matter that will incriminate him. Well, that seems obvious enough, but then the language says, or expose him to a penalty or a forfeiture of his estate. That language, if you just look at it on its surface, would seem to say that you do not have to, quote, incriminate yourself in a civil matter that might cost you money or any part of your estate. That's not what that statute means. It has been interpreted by our courts to mean penalties or forfeiture of estate that may occur as part of a criminal case. So this statute is akin to the Fifth Amendment of the Constitution of the United States. New Jersey Rule of Evidence 503 quotes the statute verbatim with certain evidence exceptions which are not immediately relevant here, and so I won't bother you with them. So what does the privilege against self-incrimination as applied in New Jersey actually protect? It protects, quote, the right of a person to remain silent unless he chooses to speak in the unfettered exercise of his own free will, and to suffer no penalty for such silence, end quote. Quote, it reflects our understanding that government is compelled to establish guilt by evidence independently and freely secured, and not by coercion, prove a charge against an accused out of his own mouth. This language comes from a New Jersey case, but it quotes the language of the Supreme Court of the United States from Malloy versus Hogan. From State versus Johnson, quote, it is intended to prevent law enforcement officers from coercing, either through physical abuse or oppressive interrogation, someone to testify involuntarily against himself. So that's what we're doing here. That's what we're talking about. We're talking about law that has been devised for the purpose of protecting defendants against, in effect, overreaching by the government, and that government being reflected primarily by you, members of law enforcement, who are trying to solve crime. And the purpose of the Fifth Amendment is to prevent you from proving your case by forcing the proof out of the mouth of the defendant. So now we know how New Jersey law, how the Fifth Amendment operates in New Jersey. Now the question that you have to think about is, are New Jersey law and federal law as to the privilege against self-incrimination always the same? And the answer is no, they're not. It would be nice in some ways if they were, because then you would only have one set of law to have to worry about. But our system doesn't work like that. And in this particular case, it clearly doesn't work like that, because as we've talked about, New Jersey doesn't operate based upon the Fifth Amendment of the Constitution. It has its own common law privilege against self-incrimination. And our Supreme Court in New Jersey has said that the common law privilege of self-incrimination is actually broader than the Fifth Amendment to the Constitution of the United States, and therefore can be interpreted by our courts to provide more rights for our citizens than are provided for generally for the citizens of the United States through the Fifth Amendment of the Constitution. You will see how our court has in fact gone beyond what the United States Supreme Court has done and has provided defendants with more rights. So if you have gotten used to thinking about federal precedent, you have to put that to some degree out of your mind and use that as only part of the picture and make sure that you understand what New Jersey case law provides, because if you merely comply with federal rules, you're not going to be good enough here in New Jersey. Obviously, what happens if there is a violation of the privilege against self-incrimination, whether it's a violation of the Fifth Amendment or it's a violation of New Jersey's common law privilege against self-incrimination? Well, the answer, of course, is that whatever is the result of the violation, in this case, usually some statement or admission on the part of the defendant, that statement or omission is going to be suppressed, and the case is going to have to be tried without it. So obviously, unless you have a case that is either so good that you don't care whether the statement of the defendant is going to be admissible or not, or so bad that you're willing to take a risk in order to try to solve the case, you have to be cognizant of the fact that if you overstep your bounds, you're likely to lose the very evidence that you are knocking yourself out to try to get. So it behooves you to pay attention to the rules and to try to do it the right way, so that when you are successful at solving the case, you're also going to be successful at being able to prosecute the defendant who committed that particular crime. Okay, so let's talk a little bit about how the outline calls it foundations of the right to remain silent, but let's talk a little bit about how we got where we are. And although Miranda is listed first and Messiah is listed second and Escobedo is third,